Good day to all. I am Weyanje and I will be discussing the case of Milagros Lumbuan versus Alfredo Ronquillo, GR number 155713, dated May 5, 2006. In this case, petitioner Lumbuan leased its lot to respondent Ronquillo for a period of 3 years with an agreement that there will be a 10% annual increase in rent for the succeeding 2 years, and the leased premises will be used exclusively for the respondent's fast food business, unless any other use is given with the petitioner's prior written consent. However, while the respondent at the start operated a fast food business, he used the premises as residence without the petitioner's prior consent. He also failed to pay the 10% annual increase in rent. Despite repeated verbal and written demands, the respondent refused to pay the arrears and vacate the premises. Thus, the petitioner referred the matter to the barangay chairman's office, but the parties failed to arrive at a settlement. The barangay chairman then issued a certificate to file action. The petitioner filed against the respondent an action for unlawful detainer before the Metropolitan Trial Court, or the METC. The METC rendered a decision ordering the respondent to vacate and surrender possession of the leased premises, to pay the petitioner the amount for unpaid rentals with legal interest until fully paid, and to pay the attorney's fees plus cost of the suit. Upon appeal, the RTC set aside the METC decision and directed the parties to go back to the Lumbuan chairman or punong barangay for further proceedings, and to comply strictly with the condition that should the parties fail to reach an amicable settlement, then the entire records of the case will be remanded to the METC for it to decide the case anew. The petitioner alleges that the parties have gone through barangay conciliation proceedings to settle their dispute, as shown by the certificate to file action issued by the Lumbuan or Pangkat secretary and attested by the Lumbuan or Pangkat chairman. The respondent, on the other hand, contends that whether there was a defective compliance or no compliance at all with the required conciliation, the case should have been dismissed. The appellate court, through petition for review, reversed the decision of the RTC and ordered the dismissal of the ejectment case. It ruled that when a complaint is prematurely instituted, as when the mandatory mediation and conciliation in the barangay level had not been complied with, the court should dismiss the case and not just remand the records to the court of origin so that the parties may go through the prerequisite proceedings. The petitioner filed a motion for reconsideration, which was denied by the appellate court, hence this present petition. In the meantime, while the petition was pending before the court, the parties went through barangay conciliation proceedings as directed by the RTC of Manila. Again, they failed to arrive at an amicable settlement, prompting the RTC to issue an order remanding the case to the METC of Manila, where the proceedings took place anew. The METC and the RTC ruled in favor of the petitioner. The main issue of the case is whether the Court of Appeals gravely erred in dismissing the complaint for the alleged failure of the parties to comply with the mandatory mediation and conciliation proceedings in the barangay level. The court held in affirmative. The primordial objective of the Katarungan Pambarangay Rules is to reduce the number of court litigations and prevent the deterioration of the quality of justice, which has been brought about by the indiscriminate filing of cases in the courts. To attain this objective, Section 412A of Republic Act No. 7160 requires the parties to undergo a conciliation process before the Lumbuan chairman or the Pangkat as a precondition to filing a complaint in court. In the case, the Lumbuan or Pangkat chairman and Lumbuan or Pangkat secretary signed the certificate to file action stating that no settlement was reached by the parties. While admittedly, no pangkat was constituted, it was not denied that the parties met at the office of the barangay chairman for possible settlement. The efforts of the barangay chairman, however, proved futile as no agreement was reached. Although no pangkat was formed, there was a substantial compliance with the law. The confrontation before the Lumbuan chairman or the pangkat is sufficient compliance with the precondition of filing the case in court. It is significant that the barangay chairman or punong barangay is herself the chairman of the Lumbuan under the local government code. It must be underscored that supervening events have taken place before the lower courts, where the parties have been adequately heard and all the issues have been ventilated. Since the records of those proceedings are with the Court of Appeals, it is in better position to fully adjudicate the rights of the parties. To rely on the records before the court would prevent the court from rendering a sound judgment in this case. Thus, the court was left with no alternative but to leave the matter of ruling on the merits to the appellate court. Wherefore, the petition is granted. The decision and resolution of the Court of Appeals are reversed and set aside, and the decision of the RTC Manila is affirmed. That would be all. Thank you very much.